Hi everyone, welcome to video 23 on major court cases in the U.S. Supreme Court. I'm going to talk to you today about important court cases for government structure, civil rights, civil liberties specific to criminal justice, and civil liberties specifically dealing with the First Amendment. And after today, we'll start on Module 4. So a couple of things here. Knowing what the court cases are basically about can help you eliminate really bad choices on the exam. And that's basically the level that as someone passing an American government course, you should be at. You should know the general categories for each case, know a few specific things about the cases, and I'll have those in parentheses by each case, and then try to know some details about the case. But your job is not to become a legal scholar of the Supreme Court or even a scholar diving deeply, as ChatGPT likes to say, into specific court cases. Instead, these are important court cases that everyone should know about, at least to the level of recognizing this case dealt with this subject. And some of our exam questions are a little tougher than that. I'm going to help you get there by being able to know the basics that you really ought to know coming out of this class. So some important court cases that deal with the structure of the U.S. government and of the relationship between actors within the U.S. government and between the federal and state government. So first of all, Marbury versus Madison is arguably the most important Supreme Court case in history because it was the one that established the idea that the Supreme Court definitely had the right, the power to overrule Congress and say that a law was unconstitutional. Now, I mentioned earlier in talking about the Constitution that that was sort of always implied because the Constitution gives the courts the judicial power, and the judicial power is the ability to apply and analyze laws, and the Constitution is the supreme law of the land. So if they're going to analyze lesser laws than the Constitution, that has to include deciding whether the laws are compliant with the Constitution. So it was always implied, but it was not a power that was specifically given to the courts in the Constitution. Marbury versus Madison is the case where they said, yes, we do have this power. And it's an interesting circumstance. So the outgoing president, John Adams, had given Mr. Marbury an appointment to be a magistrate judge, a low-level judge. And so this is an important appointment because it means he gets a salary and he gets to keep that salary for the term of good behavior. Adams left office without delivering the paperwork to Marbury. And so the new president was Thomas Jefferson, and his Secretary of State was James Madison. They were of a different political party than John Adams. And so they did not want Marbury to get the appointment, so they didn't deliver it. Thinking in today's terms, it was as if John Adams had gone through the whole process of hiring Marbury. You know, if you go for job interviews, you may go to 2 or 3 interviews, and maybe at the end of the second interview, maybe during the third interview, they tell you, congratulations, you're hired. They shake your hand, but until they send you the offer letter, it's not official. So essentially, that's what had happened. John Adams had gone through the process of picking Marbury for this magistracy, but hadn't delivered the offer letter. And so Marbury sued the Secretary of State, James Madison, to deliver his offer letter, to deliver his actual paper appointment. And Congress had passed a law that had made this particular kind of writ of mandamus that Marbury sued for uh, had given original jurisdiction to the Supreme Court over over the issue rather than appellate jurisdiction. But if you read the Constitution, the original jurisdiction is a single paragraph, or I mean a single sentence with a strong period at the end. It tells the Constitution says this is the original jurisdiction of the US Supreme Court. And then it gives the appellate jurisdiction, and it says that Congress can change the appellate jurisdiction, but it doesn't give Congress the power to change the original jurisdiction. So John Marshall, the Supreme Court justice, very influential one, um, ruled in favor of Madison and against Marbury, sort of, except the ruling actually was Congress doesn't have the authority to give us original jurisdiction, and therefore the law giving us original jurisdiction is unconstitutional, and we overturn it. So essentially, the Supreme Court said, thank you, Congress, for offering us this power that the Constitution didn't include. We're not going to accept it. We're, in fact, going to overrule it and call it unconstitutional and give ourselves even more power, the power to overrule Congress. So it was an interesting dynamic at play here. They turned down an extra power, but they got one that was always sort of assumed in the nature of the judicial system, but that had never been officially claimed. And so here they claim it. And John Adams was the second president. Jefferson was the third. So they were the presidents immediately following George Washington. This is very early in the nation's history. A little bit later in the nation's history comes McCulloch versus Maryland. It's still the same Supreme Court Chief Justice, John Marshall, but this one involves federal supremacy. And so Maryland was trying to tax the Bank of the United States. The Bank of the United States was not very popular, and the states didn't like it because they felt like it was an infringement on states' rights. It interfered with state banks. And so Maryland tried taxing it. And the Supreme Court said two things here. First of all, they said in a ruling between legitimate federal powers, legitimate constitutional laws from the federal government versus states, the federal laws are supreme. Well, the Constitution actually says that. That's kind of a no-brainer. Should have been predictable, but Maryland wanted to try its hand. The other notable thing that it said is that the power to tax is the power to destroy. So they said that Maryland's attempt to tax this federal bank was in fact an attempt to destroy a legitimate federal agency. And so therefore federal supremacy had to rule, and Maryland could not tax the Bank of the United States. So that was very important. Prince versus the United States is another federalism ruling. It ruled in favor of the states. It's much more recent. This is within the last 20 years. The situation was that the United States government attempted to force local law enforcement officials to get involved in the licensing and background checks for handgun purchases. One of these local law enforcement officials, Prince, sues the United States government saying that it's not his job to enforce federal law. And they weren't offering any money for him to do this. This was just, they passed a federal law. The federal law said he had to do it. He said, no, I don't. I don't work for the federal government. The Supreme Court agreed. They said that states are not agents of the federal government. So this applied in that case, but it also applies, it's not limited to gun rights. It's not limited to gun cases. The principle applies anytime that the federal government tries to turn local law enforcement, state law enforcement into its agent. So a really big controversial thing going on about the same time and still going on in the United States is a movement called the Sanctuary City Movement, where states, counties, and cities, especially cities, refuse to assist the federal immigration authorities in the enforcement of federal immigration law. And it hasn't come to court, I think, because the United States understands that under Prince versus the United States, they would lose because the states are not agents of the federal government. Instead, the approach that they have taken with the sanctuary cities is that they have threatened their federal law enforcement funding. So the federal government gives grants for law enforcement to local law enforcement agencies, and they've basically said, if you refuse to help us enforce immigration law, we'll take your funding away. And they're allowed to do that, but they're not allowed to force local police to be unpaid agents of the federal government. United States versus Nixon is an executive privilege case coming out of the Nixon administration. President Nixon, who was the only president to resign under threat of impeachment. The impeachment articles had been drawn up against him. Members of his own party, senators from his own party, told him that if the impeachment was passed, he would lose the trial and he would be removed from office. So he resigned. In the lead up to this, in the investigation that led to his resignation, he was subpoenaed to turn over all records, including tapes that he made, audio recordings that he made of all his conversations in the Oval Office. And he did not want to give them up. Once he gave them up, this was the final straw that made his impeachment inevitable because there was damning evidence in them. There was also a deleted section that even the deletion was an issue. But he tried to claim that he had executive privilege, that he should not have to reveal recordings of the Oval Office because it damaged his power to privately speak with his advisors. The Supreme Court ruled that that executive privilege did not make him immune from the subpoena. So he turned over the tapes and eventually ended up resigning in disgrace. Bush versus Gore is a 2000 case that involved the 2000 election. It was a highly controversial election in the United States. At the point at which this suit was filed with the Supreme Court directly, the Bush-Gore election day had been weeks before, but Al Gore had still not conceded the election. The election returns show that he had lost, but he was demanding that 4 counties in Florida, a state that was right on the edge, that 4 counties have a hand recount. These were 4 counties that he felt he would win enough extra votes during a hand recount to take the state of Florida, which would have given him enough electoral college votes to be elected president of the United States. He had gone to court in Florida and the recount had started. The Bush campaign went to the United States Supreme Court claiming that only recounting 4 counties violated the Equal Protection Clause, at least partially because there were racial disparities between the counties that Gore wanted to recount and the rest of the state. So Bush versus Gore, Bush claimed, the Bush-Cheney campaign claimed that this was an equal protection violation. The Supreme Court agreed and said that equal protection applies to elections. They ruled in favor of Bush and stopped the hand recounts in the 4 counties that Gore wanted. Gore conceded the election shortly afterwards, and Bush was elected president of the United States. Vice President Gore was actually the presiding officer in the Senate when the electoral votes were counted and did not raise any objections as vice president during the counting of the electoral votes. Some people to this day believe that Gore would have won if the recount had happened. There have actually been studies by academics who did hand recounts of the state of Florida, including those counties. They did them several different ways. And the conclusion was that if Gore's hand recount had proceeded, Gore still would have lost. So it was the right call both on the law, because they properly applied equal protection, and on the facts, although they didn't know it, which is that the only thing that the hand recount would have done was leave 2 or 3 more weeks of uncertainty about who had won, and Bush would still ultimately have been president. So it's an interesting case. It's probably more interesting to people who lived through it, um, but like me, um, but it is an interesting case overall, even beyond what happened with the Supreme Court. It was high politics at the highest level of the United States, and it was a very dramatic period in American history. It wasn't eclipsed in terms of the drama of presidential elections until 20 years later during the 2020 election. So what about civil rights cases? So civil rights are things that deal with discrimination based on some protected class. And most of these have to do with race. Most of these cases, not civil rights generally, but although there was a huge, the name civil rights gets its name from the racial civil rights movement, specifically the African American civil rights movement. So the first case, and one that went badly, one that went the wrong way, um, before the U.S. Civil War, the United States had legalized slavery, and Dred Scott versus Sandford dealt with this. And it was a major reason, it was a major thing that made the Civil War inevitable. Dred Scott was a slave owned by a physician named Sanford. He traveled with Sanford. He was his personal valet. He helped him getting ready for the day, did valet things, helped him laying out his clothes or whatever, the kinds of things valets do. I'm not rich enough to have one, so I only have a second-hand idea of it. It wasn't a bad gig. If he hadn't been a slave, it would have been a pretty nice job, actually. Um, but he was a slave. He couldn't quit. He couldn't go find another job. It put him in an inferior status. Well, Sanford traveled a lot. He traveled between states, and at some point he traveled into Illinois and some other states that were free states. So Dred Scott filed a civil suit in the federal court in St. Louis, Missouri, against Sanford, uh, saying that since he had traveled into a free state, he was no longer a slave. It eventually wound its way to the Supreme Court, where Justice Taney was the Chief Justice, and Justice Taney was a horrible racist bigot who wanted to keep African Americans in their place, and he was in favor of slavery. And he the Supreme Court, he led the decision that denied citizenship to all African Americans. Not only, he didn't just say that Dred Scott couldn't file the suit because he was a slave. He said Dred Scott couldn't file the suit because no African American, including free African Americans, was a citizen of the United States. That was not resolved until after the Civil War, when the 14th Amendment made the freed slaves citizens. Plessy versus Ferguson was a case. I talked about this a little the other day. It said that separate but equal were allowed. So I went through this in talking in the portion on talking about stare decisis and precedent, how Plessy versus Ferguson was overturned by Brown versus the Board of Education, that ruled that separate is inherently unequal. So Plessy versus Ferguson said separate but equal was allowed. This is 1896. Brown versus Board of Education came in and said, no matter how good the facilities are, if they're separate, they're inherently unequal. And so remember, Brown versus Board of Education was the Topeka, Kansas case where the facilities for black students and the facilities for white students were both exceptionally good. They were equal to each other, and they were better than the facilities in a lot of other areas, in a lot of the surrounding areas. They were just excellent schools in both cases. But Brown versus Board of Education said just because they were separate, that made them inherently unequal. It was inherently discriminatory to say to black people, you can't go where white people go. Uh, Sensible. So we've got two really bad decisions. Now we get a good one. Virginia versus Loving, which is in the late 60s, early 70s, um, involved interracial marriage. The couple had gotten married in Washington, D.C., where interracial marriage was allowed, and they had moved to Virginia, which is the suburbs of Washington, D.C., and interracial was not allowed, and they were charged with miscegenation, that is, being married when they were of different races. It went all the way to the Supreme Court, and the Supreme Court said marriage is a fundamental right, that the right to choose who you marry is a fundamental right, and that denying it on the basis of race violates the 14th Amendment guarantee of equal protection of the laws. Obergefell versus Hodges in 2015 did the same thing with same-sex marriage, except that since race was not involved, they could not rely entirely on the Equal Protection Clause, because it's equal protection regardless of race. And so they couldn't rely on that. It took longer to get there. It took 40 years, 45 years to get to Obergefell versus Hodges, where the Supreme Court said the right to choose who you marry is just a fundamental right of citizenship. Everybody, race notwithstanding, race not even being involved. And so same-sex marriages are protected too. Uh, excuse me. So moving from civil rights to civil liberties, I'm going to talk about some civil liberties cases. So civil rights deal with discrimination on the basis of some class that someone belongs to. Civil liberties involve protections for citizens against government abuse and tyranny. So protection for rights against the government specifically. And these apply to everybody, so they're not just protecting a single race that's been discriminated against, or gender or other class, but just protecting people in general. So Griswold versus Connecticut was an important civil liberties case that created the right to privacy. Connecticut made the use of contraceptive birth control illegal. Um, and Griswold was the other side of this case, the private party that was affected by this ban on birth control. It made its way to the Supreme Court. The Supreme Court said, using the idea of substantive due process, that there was a right to privacy that was part of the penumbras of the Bill of Rights. Essentially, that if you read the full Bill of Rights, there's nothing in there about a right to privacy. But if you read them all and you look at them with the idea of what are fundamental rights that are part of ordered liberty, that the right to privacy is one of these. And therefore, by violating the right to privacy, this birth control ban violated substantive due process and violated the Constitution. A couple of important things to note here. First of all, the Griswold was a married couple, and it was a right to, this case actually only established a right to marital privacy. So they said that the privacy of the marital bedroom should not be subject to state control in this way. That was important in a bunch of ways, but one part of that is realize here we're talking about a right to privacy that actually only applies to married people. But over the next few years, pretty rapidly, it ends up applying to everybody, because for one thing, having birth control legal for married couples and illegal for everybody else would just be a practical enforcement nightmare. But even more than that, it just became applied to everybody. Should your bedroom be any less private because you're not married? Was the kind of question. By 1973, it applied to everybody, and there was just a right to privacy. Marital wasn't part of it. And Roe versus Wade legalized abortion for the first trimester, limited regulation in the second trimester to protecting the state's interest in the health of the woman. That's not a civil liberty. That's a state interest. It allowed prohibition to protect the state interest in the fetus life and health in the third trimester. So that's also a state interest. The only part of this case that championed a civil liberty was the legalizing of abortion in the first trimester. The decisions related to the second and third trimester were uh, state interest cases, not they were, if anything, they overruled the civil liberty that was created for the first trimester. So it was very much a mixed bag. Casey versus Planned Parenthood, which I talked to you about during the part on stare decisis or precedent the other day, narrowed Roe versus Wade, allowing more regulation of abortion in some cases, but also setting a standard that regulation of abortion could not be an undue burden on the right to abortion. So while it narrowed the time frame a little bit, changed the thing away from this trimester time frame, and allowed more regulation, but also required that the regulation not place an undue burden on the liberty that was being considered this right to choose abortion. Um, then, however, Dobbs versus Jackson Women's Health Organization overturned both Roe and Casey and all of the other abortion laws from 1973 that had relied on them, made abortion a state issue, did not ban abortion nationwide. There is no nationwide abortion ban. The U.S. has laws on abortion that range from on demand abortion during all 9 months to no abortion except in the case of the life of the mother of the woman. So the U.S. has a full range of laws, and it is not a national issue. There cannot be a national ban of abortion under Dobbs versus Jackson Women's Health Organization. So this overturned the civil liberties aspect and made this entirely about state interests or state powers. Lawrence versus Texas was a 2000 decision, actually on a case that started in Houston, Texas. Up until that point, almost every state in the nation made it illegal for homosexuals to have sex. The charge was sodomy. Uh, Lawrence versus Texas applied the right to privacy and essentially said that the right to privacy applies just as much in a homosexual couple's bedroom as it does in a married couple's bedroom, and overturned the state's sodomy laws. This was a Houston case that arose about 6 miles from where the University of Houston is located. So Lawrence and his partner were engaged in homosexual sex. The state charged them. A Harris County deputy arrested them, and it eventually came to the United States Supreme Court. Um, so, and the United States Supreme Court found against Texas, and overturned the law, making sodomy illegal. Moving on to some more civil liberties, in this case, those that specifically involve criminal justice. So those involve potential crimes, but these involve just general questions of criminal justice. Gideon versus Wainwright applied the right to counsel from the Bill of Rights to states. So the Bill of Rights initially only applied to the federal government because the states had their own bills of rights. Texas is the first thing in the Texas Constitution is the Bill of Rights. It was similar with the Virginia Constitution at uh, at the beginning of the United States. The Virginia's original Constitution was just a Bill of Rights or a Declaration of Rights. It eventually became a full-fledged Constitution, but there was no application of the Bill of Rights to the states until the 20th century when the 14th Amendment was used to apply the Bill of Rights to the states. Gideon versus Wainwright said that right to counsel from the U.S. Bill of Rights has to apply to the states. States have to allow people to have counsel. An accompanying ruling, not accompanying, but ruling along the same lines said states have to allow the right to counsel during questioning, not just at trial, but someone has the right to an attorney during questioning by the police. And Gideon versus Wainwright said that the right to counsel didn't just mean that they had to let you hire a lawyer with your own money if you were accused of something. The state actually has to pay for it for someone who can't afford a lawyer. Miranda versus Arizona said that the police must inform suspects of their rights before questioning. And the specific rights that they have to inform suspects of are the right not to incriminate themselves, which they're supposed to say as you have the right to remain silent. Anything you say can and will be used against you in a court of law. Well, actually, if you give up this right, anything you say can and be used against you in a court of law. They're supposed to read it off of a card so that they don't mess it all up like I just did. That's not it. It goes on. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you by the courts. And then they're supposed to ask the suspect, do you understand these rights as I've read them to you? And at that point, if the suspect continues to talk to them, then they're covered. The things the suspect says can be used against them as evidence in court. But this laid this out because before that, police would arrest people and question them without telling them they had the right not to talk. And so people would make confessions, sometimes false confessions, because they didn't know they had a right not to talk to police. Terry versus Ohio involves something called stop and frisk. And it, in fact, is the thing that made stop and frisk at least confirmed that it was okay. Terry versus Ohio is that if police reasonably stop someone for questioning, they have a reason to question someone, such as a crime being committed in the vicinity, and they see the person and they match the description of the suspect. Or it's just a really high crime area, even can be a reason to just talk to somebody. And at that point, they can say, can I talk to you? The person can say yes or no. If the person agrees to talk to them, then they can say, can I search you? For my own protection to make sure that you're not carrying a weapon. And that's the reason for the search. It's a reasonable search during questioning to make sure they're not carrying a weapon. That's allowed. Since it's allowed, if during the search they find some evidence of a crime, the person can be charged with the crime. There are other cases that clarify the limits. For example, what's reasonable and so on. But the idea that if there's reasonable cause for questioning and a reasonable reason for the search, generally to protect the officer from the danger that the person is armed, that's okay. But it's all about reasonable, right? So an unreasonable search or an unreasonable questioning is not protected. It has to be reasonable. It has to be something that a judge and jury would agree was reasonable. Mapp versus Ohio, and this is important when we get down to Mapp versus Ohio, which says that the federal exclusionary rule, which is just a procedural rule in federal courts, that says evidence obtained illegally cannot be used in court. Well, Mapp versus Ohio applied that to the states, which means that if the person doesn't have a lawyer and hasn't been given the opportunity to get a lawyer, and they make a confession, and the confession leads to other evidence, that evidence can't be used. If the police don't give the Miranda warning properly, the person isn't informed of their rights, and they give up information that leads to evidence, that evidence can't be used. If a Terry stop happens and for some reason it's not reasonable, for some reason it violates the rules, then the evidence obtained would be illegal. It can't be used in court. A lot of people call this a technicality. It is not a technicality, it's the law, and law enforcement officers' job is to enforce the law. If they fail to even follow the law themselves, they are not enforcing it, and it is not a technicality. It is a failure of the police to do their job properly. So I'll skip Escobedo versus Illinois since I already talked to you about it. That I'll just reiterate the idea is that having the right to counsel only during the trial isn't sufficient. You have to have the right to counsel throughout the entire investigation if you're accused of a crime, from the very first questioning by police. Furman versus Georgia is the case that struck down all death penalty laws in the United States for a period of 7 years. And it was based on the Georgia law. So Georgia ended up being the one that had the next case, Gregg versus Georgia, where the death penalty was reinstated. So you can remember F for Furman comes before G for Gregg. Furman struck down the death penalty. Gregg versus Georgia reinstated the death penalty. Roper versus Simmons said that minors cannot be executed, and actually you cannot execute people for crimes committed before they were 18. Atkins versus Virginia said that the mentally impaired, that is, people with intellectual disabilities, cannot be executed. So what about some important civil liberties cases involving the First Amendment? So the First Amendment is freedom of speech, freedom of religion, freedom of the press, the right to petition the government for redress of grievances, no establishment of religion. It's all about freedom of expression and freedom of conscience. Most of these deal with the free speech aspect, or the freedom, what we call just generally freedom of expression cases. So Schenck versus the United States was a case during World War I that involved anti-war protests and anti-government protest in general. And so free speech, people being arrested for opposing the government with their speech, the Supreme Court ruled that there had to be a clear and present danger. So inciting to riot is an exception to violating speech, to violating free speech. If someone's inciting a riot, they can be arrested, but it has to be a clear and present danger. Somebody standing around with 3 people talking about how maybe next week we should get together and riot wouldn't be a present danger. If it was 3 or 4 people, it probably wouldn't be a clear danger either. On the other hand, someone haranguing a crowd of 1,000 to go, to go rioting would be a clear and present danger. And so they made that the standard. West Virginia State Board of Education versus Barnett was in 1943. This also was in the middle of a war. It was in the middle of the largest war ever fought in the history of the world, World War II. Students in West Virginia Board of Education made a law that periodically students had to salute the flag and say the Pledge of Allegiance. The saluting the flag was the part that they could be disciplined for not saluting the flag. During this period, every day or week, they had to do this. Jehovah's Witnesses students, Jehovah's Witnesses do not believe in saluting the flag. So this is a free speech case and a freedom of religion case. And during the middle of the war, the Supreme Court ruled that students could not be forced to salute the flag. So during the middle of the war, it was okay for students to resist the government's effort to make them support the government by saluting the flag. Uh, that's that's the kind of real freedom that defines what the United States is supposed to be. In the middle of the biggest war in human history that we were a part of, we said, yeah, it's important to salute the flag, but it's more important to have the right not to. Brandenburg versus Ohio, 1969. This is Vietnam War era. And the important thing here to remember is just that this is a free speech case that changed the standard from clear and present danger to imminent lawless action. So it's actually a little stricter standard. Clear and present danger means, yeah, there's a clear danger. Yeah, it's present. It's not necessarily imminent. Imminent is lawless action is about to occur. So a change in the standard for free speech, for when free speech can be limited. Tinker versus Des Moines, 1969, the middle of the Vietnam War. Um, this is a case of high school students um, protesting the war. This war involved a military draft. Students, when they hit 18 years old and graduated from high school, if male students had to register for the draft, if they didn't have some kind of physical disability or didn't get into college or have some other exemption, or volunteer for some branch of the armed forces, they would be drafted and usually put in the army and sent to Vietnam, where there was a high likelihood they would be seriously injured or even killed. Uh, so all of these students are approaching 18 years old, approaching graduation. For the male students, what they were protesting was the possibility they could be sent to die against their will. For the female students, it was the possibility their friends, their boyfriends, their fiancés, people they knew and loved, and friends they knew and loved could be sent against their will to fight and die in the jungles of Vietnam. These students protested by wearing black armbands to school. The Des Moines School District said the black armbands violated their dress code and took disciplinary action against the students. The Supreme Court ruled the students had the right to protest, and they said that the rights of students do not end at the schoolhouse gate. That is the quote, the takeaway. The rights of students do not end at the schoolhouse gate. They still have the rights to free expression. They still have their civil rights, their civil liberties as citizens, despite being in high school. Some more important First Amendment cases. The first one is also during the period of the Vietnam War, also involves the draft. 1971, California had a disorderly conduct law against using offensive speech or profanity. Mr. Cohen was wearing a jacket. So the picture here, first of all, is somebody burning their draft card. This is something that um, that was done. They would burn up their draft card to show their protest against the war, and then a lot of those people left the country. A lot of them moved to Canada. Mr. Cohen was of draft age in California, and he was wearing a jacket that across the back was emblazoned with the words, "Fuck the draft." Um, don't worry, I won't use that word constantly. but the Supreme Court said it's protected speech, so I can say it. And more importantly, Mr. Cohen was allowed to say it. California had tried to prosecute him for disorderly conduct for having this jacket that said that. And the Supreme Court said, no, that's protected speech. In fact, offensive speech, not necessarily profanity, but offensive speech is the most important kind to protect. If speech offends no one, there's no need for it to be protected because no one will object to it. It's only offensive speech in one way or the other which requires protecting. And in this case, the offensive part was the specific dropping of the F-bomb on the back of his jacket. But the Supreme Court ruled that was protected. Texas versus Johnson was another offensive speech case. In this case, again, our state here, Texas, violating Johnson under a statute that said you can't burn the American flag. The Supreme Court ruled that yes, Mr. Johnson could burn the American flag. It was allowed. And so flag burning is protected speech. And interestingly here, Cohen and Johnson both, neither of them was an actual speech. It was, in one case, the word written on the back of the jacket, which we could at least say is something like speech. But Johnson, it was purely symbolic expression. He didn't even have to say anything. Just burning the flag sent the message he wanted to send, and the Supreme Court ruled that that purely symbolic expression of burning the flag was still protected speech. So finally, uh, Citizens United versus the Federal Election Commission. The Federal Election Commission was set up to regulate spending on elections, primarily spending by candidates on elections, and then it allowed the candidates to spend. It allowed groups called political action committees to donate to candidates, but the federal election laws enforced by the FEC prohibited corporations from spending any money on political causes, on advocating for the election of officials, on politics. And the argument was, now Citizens United was a nonprofit corporation, but it was still a corporation. And Citizens United claimed that that corporations have free speech rights, and that to exercise those free speech rights, the only way that a corporation can exercise free speech rights is by spending money to buy advertising. Remember that the United States Revolution, the American Revolution against Britain, was all about the slogan. One of the major slogans behind it was no taxation without representation. Corporations, especially for-profit corporations, pay taxes, but they're not at all involved in electing public officials. So they have no direct representation through elections. The only representation they have is if they can engage in free speech. And for a corporation to engage in free speech in the environment in the United States today, and at the time of Citizens United about 10 or 15 years ago, the only way for them to do that is to spend money to buy political advertising. So the ruling was political advertising is free speech. Corporations do have rights, and those rights include free speech rights. It's entirely consistent with the idea of no taxation without representation, because we certainly do tax corporations. So there have been some other related laws and decisions around that, but that's the important one that establishes the right that corporations can actually engage in politics through buying advertising, which is an important free speech case. That is it, and I will talk to you soon about some Module 4 topics.